Mr. Justice Witt, Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana, judgment delivery in Consolidated Appeals of GYCV number 1 of 2022, the Attorney General and Monica Thomas and others, and GYCV number 2 of 2022 between Bharrat, Jagdeo and Monica Thomas and others. The members of the delivery panel are Mr. Justice Witt, presiding judge.
Good morning, Counsel.
Mr. Justice Anderson. Madam Justice Rajnath.
Good morning, everyone.
Mr. Justice Barrow.
Good morning, Counsel.
And Mr. Justice Jamadar.
Good morning, everyone.
May we have the appearances, please? Thank you.
Morning, Your Honors, and morning, everyone. If it pleases you, Nigel Hawk appearing on behalf of the appellant, the Attorney General in GYCV 1. Appearing with me is Ms. Pratima Kisoon, Ms. Trishana Lal, Ms. Rihanna Clark, Mr. Chevy Devonish, and Ms. Asasha Ramzan, and we're led by the Honorable Attorney General, Mr. Mohamir Anand Nandlal, Senior Counsel, who's asked respectfully that his absence be excused with Your Honor's leave. Obliged.
May it please the court, Devendra Kisoon with Natasha Rivera, Clay Hackett, Rishi Das, all led by Douglas Mendez, Senior Counsel, on behalf of Mr. Bharrat Jagdeo in both matters.
Good morning, Your Honors. My name is Roysdale Ford, and together with Mr. John Jeremy, Senior Counsel, Mr. Kemraj Ramchatan, Mr. Mayor Robertson, and Mr. Selwyn Peters, we appear for the first and second respondents.
Good morning, Your Honors. May it please the court, Kurt De Silva, appearing for the Chief Election Officer.
Good morning, Your Honors. Bassel Williams, Senior Counsel, appearing for Mr. Granger, representative of the AP and UXC list. Are you hearing me, Your Honors?
Yes, we are hearing you.
Yes,
Justice, are we finished with the appearances? I'm only asking because Mr. Justice Anderson has indicated he's not hearing us. So we have asked him to leave the call and to return. So we may need to, we just need to pause for a moment. Justice Anderson, are you there with us? Are you hearing us now?
Well, apparently not. Maybe Justice Anderson could go and come back.
Justice Witt, I've asked our Deputy Registrar Acting. We will pause the matter for a moment, not be on live stream until we rectify what's happening with Justice Anderson. Could we do that, please, Judge?
Yes, you can do that.
Thank you. Yes, Counsel, please remain in the space. We're just trying to work out our technical challenges. Thank you so much.
Okay.
Yes, Judge, I'm hearing you. So you are not hearing me? Oh. About 4 more persons to do.
Yes, I think we could continue. I think
continue, right? So the next person, I think, I don't know. We had Mr. Williams and we had Mr. Jonas. I'm not sure where we are because I was not following at the time.
We had Mr. Curtis
Council,
Silva.
please, you would know where we are. Please make the appearances as per usual. Thank you.
You haven't had Mr. Jonas yet, Your Honor, so allow me to come the line, please.
Mr. Jonas.
And appear for the 8th, Sasha Kisoon. Thank you very much.
May it please, Your Honors, I'm Ganesh Hira, and I appear for Vishnu Bandhu, the representative of the United Republican Party.
May it please, Your Honors, Mal Rafran appearing for Jonathan Yearwood, who is a representative of a new and united Guyana.
Good morning, Your Honors. May it please the court, Kashir Khan with Mohammed Khan, Ivan Alert, Kalish Lokman, and Joshua Abdul, and we appear for Shazam Ali.
Okay, I think we got through the list. So I think we are ready then to deliver a judgment. There is a matter of seriousness that we need to go through, but I want to have the judgment delivered first, and then we will speak about that other matter about a premature announcement of the judgment as far as we have heard. But let's not talk about that now. Let's deliver the judgment. So I will ask Justice Anderson to deliver the judgment.
Thank you, President, and good day to everybody. General elections and regional elections were held in Guyana on 2nd March 2020. After the declaration of the results, in August 2020. Election Petition 99P 2020 was filed on 15 September 2020, challenging the validity of the results and seeking an order that the elections be deemed unconstitutional, null, void, and of no legal effect. Election Petition 99P 2020, along with Election Petition 88P 2020, were heard by Chief Justice Roxane George, acting. The Chief Justice, at a case management conference, raised the issue of whether Mr. David Granger, representative of a Partnership for National Unity and Alliance for Change, was a proper and necessary party to the petition, and whether Mr. Granger had been properly served. As a proper and necessary party, Mr. Granger should have been served with Election Petition 99P 2020 and the supporting documents within 5 days of filing of the petition, as required by Section 8 of the National Assembly Validity of Elections. Validity of Elections Act, Elections Validity Act, and Rule 9.1 of the National Assembly Validity of Elections Rules, Election Validity Rules. That is by 21 September 2020. In fact, Mr. Granger had been served on 25 September 2020. Accordingly, the Chief Justice dismissed the petition, ruling it was a nullity. The petitioners, now first and second respondents, appealed against the Chief Justice's decision. The Attorney General and Mr. Jagdeo, the appellants, objected and applied to strike out the appeal on the ground that the Court of Appeal lacked jurisdiction to hear and determine the appeal. The court's election petition jurisdiction is to be found in Article 163 of the Constitution. According to Article 163(3), an appeal to the Court of Appeal shall lie from the decision of a judge of the High Court granting or refusing leave to institute proceedings for the determination of any question referred to in Article 163(1), or from the determination by the High Court of any such question or against any order of the High Court made in consequence of such determination. The Court of Appeal, by majority, found that an appeal lies to the Court of Appeal through Article 123 of the Constitution and Section 6(2) of the Court of Appeal Act, and that the exercise of the ordinary jurisdiction of the court was not excluded by the special jurisdiction created by Article 163 of the Constitution. The Court of Appeal accordingly held that it did have jurisdiction to entertain the appeal. The Attorney General and Mr. Jagdeo then appealed to the Caribbean Court of Justice. The judgment of the court was delivered by Anderson JCCJ, with whose reasoning Witt JCCJ and Rajnath Lee JCCJ agreed. The overarching issue was whether the Court of Appeal was correct to hold that it has jurisdiction to hear an appeal from the decision of the High Court dismissing the petition on ground of non-compliance with the Elections Validity Act and the Elections Validity Rules. The court noted that there are 3 possible grounds on which such jurisdiction may be based. The first ground is Article 163 of the Constitution and the Elections Validity Act and Rules. Anderson JCCJ explained that the fundamental proposition to be derived from Article 163 and from the Elections Validity Act and Rules is that they establish a comprehensive regime for challenges to an election. Election Petition 99P 2020 had to be determined in accordance with this framework. Rule 9 was breached, and so it fell to the High Court, the court before which the petition had been presented and in which exclusive jurisdiction was vested by Article 163 of the Constitution and Section 3.1 of the Elections Validity Act to determine the issue of non-compliance. It could not be accepted that proceedings which began in the High Court under this exclusive, exclusionary, and special jurisdiction for dealing with election petitions suddenly transmogrified into ordinary civil law proceedings on appeal. Neither is it permissible to depart from or import into, by implication, a jurisdiction not created in the article. The court emphasized that Article 163.3 circumscribes the right to appeal decisions of the High Court in election petitions to only 2 circumstances. The Chief Justice struck out the petition on the basis that there was improper or late service on Mr. Granger. Her decision did not fall into either of those 2 circumstances, and thus no appeal was possible. As to whether jurisdiction could be based on Article 123 of the Constitution, coupled with Section 6 of the Court of Appeal Act, the majority disagreed for 3 reasons. First, the special elections jurisdiction in Article 163 of the Constitution and the Elections Validity Act and Elections Validity Rules must prevail over the general civil law proceedings jurisdiction contemplated by Article 123 of the Constitution and Section 6.2 of the Court of Appeal Act. Secondly, there exists the broad and fundamental principle that general provisions in a statute must yield to specific provisions. And thirdly, any tension between Article 163 of the Constitution and Section 6.2 of the Court of Appeal Act concerning the election jurisdiction must naturally be resolved in favor of the Constitution. As to the third and final ground, Anderson JCCJ noted that there may be an exception to the rule as to the Court of Appeal's jurisdiction in order to maintain the integrity of the Constitution, a possibility considered by this court in Coffey and Skerritt. He opined that procedural as well as substantive errors may be a basis for arguing that there should be a right of appeal to the Court of Appeal, but that the threshold for making such an argument is necessarily very high. In this case, however, there was no real suggestion from the respondents that the Chief Justice's decision in dismissing the petition for want of proper service could support an argument that could justify invocation of the exception. In an opinion that concurred in the result, but differed as to reasons, Bharrat JCCJ observed that it must be considered that while exclusive jurisdiction is given to determine primarily the validity questions listed in Article 1631, the general jurisdiction is not excluded from operating when the question being determined is not a validity question under Article 1631. The Chief Justice's decision to dismiss the petition as a nullity in this case demonstrates that what was appealed in this case was not a validity question under Article 1631 with its restricted right to appeal, but an ordinary question of law regarding service of process as required under the Elections Validity Act and rules. The invocation of jurisdiction was not solely in relation to validity questions under Article 163. He continued that Article 1631 was not in play in this case, but rather Article 1634, which gives power to Parliament to legislate with respect to the practice and procedure of the High Court in relation to jurisdiction and powers conferred upon it by or under Article 1634C. In crafting these legislative provisions, Parliament included Section 42 of the Elections Validity Act and Rule 21 of the Elections Validity Rules, which gave the court the same powers, jurisdiction, and authority in election petitions, quote, as if the proceedings were an ordinary action, end quote. These provisions were thought opposite to answering the question of whether the decision to dismiss the petition is subject to the Supreme Court's general jurisdiction in the same way as an ordinary action. In an ordinary action, a dismissal of a claim for improper service would be subject to consideration under the general appellate jurisdiction of the Supreme Court. Of course, that did not mean that an appeal lies against the decision, but rather that the decision may be reviewed to decide whether the right of appeal given by the High Court or the Court of Appeal Act includes that decision. In this case, several indications made it clear that the Chief Justice's order dismissing the petition was an order made in chambers. Section 6(2)(a)(1) of the Court of Appeal Act places an order made in chambers in the same statutory boat as an order made in summary proceedings, where no right is given to appeal to the Court of Appeal. The result must be that the purported appeal by the then petitioners against the dismissal by the Chief Justice of the petition in this case as a nullity is itself a nullity because there was no right of appeal to the Court of Appeal. In concurring, Jamadar JCCJ agreed with Bharrat JCCJ that the decision to dismiss the petition for failure to comply with statutory requirements as to service was an exercise of judicial discretion pursuant to the powers, jurisdiction, and authority provided for by Section 42 of the Elections Validity Act and Rule 21 of the Elections Validity Rules. Thus, any right of appeal as to service of an originating process is to be sought within the ordinary powers, jurisdictions, and authority of the court incorporated by Section 42 of the Elections Validity Act. An appeal of such a decision does not lie in the Court of Appeal, but to the full court. He observed that in Guyana, the deep basic structure and core constitutional values and principles to be found in Guyanese constitutionalism should guide a court when faced with choices as to multiple interpretations of statutory provisions. This is especially true in relation to provisions that implicate core constitutional values such as free and fair parliamentary elections. He suggested that the narrow jurisprudential issue in this case, in this appeal, needs to be placed, contextualized, and understood through the lenses of democratic governance in Guyana, the role of the courts, and the learning to be found from authorities such as Hines against R, Williams against Mayor of Tenby, and R. Willis against Parliamentary Election Court. Sorry. As to the interpretation of Section 42 of the Elections Validity Act, Jamadar JCCJ explained how Section 42 could be constitutionally reimagined and reinterpreted by liberating the meaning of subject from its colonial mindset. By doing so, Section 42 becomes accommodating of a more permissive, purposive, and inclusive interpretation and application that permits an appeal to the full court. This approach to Section 42 is reasonably justified in the particular circumstances of this case, where the issue is whether a right of appeal lies from a decision striking out an election petition for late service. Now, having regard to all the opinions expressed in this case, the appeal was accordingly allowed and the decision of the Court of Appeal set aside. The court ordered that each party bear their own costs. Thank you, President.
Thank you, Justice Anderson. I think, well, it's a good thing that we had a decision with sound, which would make it a sound decision. But there's something more serious to discuss, which is it was brought to our attention that this decision of the court, which was an advanced copy was provided to counsel, as is the custom of the court, which is a service of the court, that decision was already publicized on the Facebook page of the Attorney General. That is what was brought to our attention, which is, of course, a very serious and unacceptable thing. What we want to know, of course, this was brought to our attention, so I would like to invite the counsel for the Attorney General, I suppose that's Solicitor General Hawke, to give his views on what happened.
Oblige, Your Honors. Your Honors, first we'd like to place our sincere apology to the members of the court and to our learned colleagues. But what transpired, as I've instructed, and I should say that the learned and Honorable Attorney General was traveling and is on government business in Barbados, and I'm instructed that an unauthorized note, the judgment wasn't published, an unauthorized note was published on his Facebook page, and when it was brought to the attention, it was immediately pulled. We'd just like to say for the record that it was not the judgment. A note was placed on his Facebook about the judgment, and be that as it may, Your Honors, we would like to place on the record our most sincerest apology to yourself, the President, and other members of the panel. We would like to say it was in no way intentional. It was in no way intended to bring the administration of justice of the court into disrepute. And we plea and we hope that this court will find grace and forgiveness for that sincere error on the part of the administrator of the page. But that was the situation, Your Honors. It was an unauthorized publication of a note and not a judgment, but that in itself is still a breach, and we sincerely apologized.
Your Honor.
Yes.
Your Honor, Stelvin Peters, one of the co-counsels for one of the respondents. Your Honor, what I would say in this case is that irrespective of whether it was the judgment itself, it was the content and the result of the judgment that was published. There was an implied undertaking in Canada, where I also practice law. We actually signed an undertaking prior to the release of these judgments that are embargoed, but the CCJ's practice is not that. But the undertaking still remains. What that premature release did, it was shared all over the internet, and what it did is it put the administration of justice into disrepute. Because if Your Honor's staff read the comments, it almost seemed like the Attorney General had some privy, but we were not allowed to say that all lawyers got an advance copy of that judgment. We were not allowed to comment on it, but the comments with respect to the CCJ was not comments that puts the CCJ in a positive light. And so I appreciate the Solicitor General's apology. That page is the Attorney General of Guyana's page. The Attorney General of Guyana is the Chief Law Officer of the state. He's the representative, the leading counsel of the bar. What happened there was unacceptable. The apology is not accepted because it put the CCJ into disrepute. And those are my submissions.
Yes, anyone else who wants to shed a light on this? Mr.
President,
Yes?
before you ask about shedding a light, in what I heard, did the counsel for the Attorney General, apart from indicating the apology to the court, did he indicate to us that he would issue that apology publicly on the fora that the offending notification or notifications were posted? I'm just trying to recall whether that was stated to us or not.
Your Honor, if it pleases you, it was not, but that would not be a problem. We wouldn't have a problem going the additional extra step and putting it on the record on the Facebook page that was published. That it's a public apology that we're making. That is not
you heard, Mr. Peters, the impression was created that, okay, the Attorney General has some hidden line with the court. He gets this first and no one else knows about it. We know that that is not so. But anyway, this is just an example of how these things may affect. Would you agree, Mr. Orr?
Your Honor, I'm in full agreement, and that is why I at the outset sought the court's kind indulgence for forgiveness and mercy and grace, because I fully understand the situation. That is as best as I can do. It has happened already, unfortunately, and we are placing our most sincere and profound apology for that error. And Your Honors, I leave it now to Your Honors' grace and judgment in that regard.
Yeah,
Mr. Hawk, for perfect clarity,
yes, please.
Can I take it that the Attorney General's chambers, the Attorney General will himself ensure that he's undertaking that an apology will be published?
That is the position, please, Your Honor.
Okay. Now, Mr. Peters, you were saying an apology is not sufficient. Okay, we now heard from the Solicitor General that the apology will be published, that the Attorney General is undertaking to do that.
Justice Witt, may I interrupt you? I see Mr. Justice Anderson's, his hands are up.
Yes, Justice Anderson.
Yes, thank you, President. And I have listened with great interest to what has been said. I was not aware of the breach of the confidentiality. I would say, sir, that this discussion is useful, no doubt. And we have heard what we have heard. However, there are much more profound issues at stake, and those issues I do not believe can be fully ventilated in this forum. I think the court will have to decide how to go forward in relation to the release of these advance copies, possibly generally, and certainly in relation to sensitive matters such as this one. And I believe that that's a discourse that the court should have with itself, led, of course, by our permanent president, to decide how to go forward. I really don't think that this forum, beyond what we have heard, is going to be very, very helpful in deciding how we go forward. I do take the point that we expect an apology from the Attorney General himself. No doubt that will be forthcoming. But beyond that, sir, I do think that this is a policy decision that we need to discuss and decide amongst ourselves. And I say that particularly in the context of the fact that we have another hearing which is upon us and I have to do a couple of things before that hearing starts. So I would pray your leave and indulgence by suggesting that we, having heard what we have heard, defer the matter for consideration by the bench itself. Thank you.
Yeah, Justice Anderson, I was minded to withdraw shortly and discuss this, but given the time problem, I can understand that that might take too much time. But I think we have expressed ourselves clearly enough to make it very clear that this is totally unacceptable. And any further action of the court will be contemplated. For example, is it possible in cases like this to send an advanced copy in Guyana? I mean, this is really serious business, and we cannot have it. And this is something we will discuss in a broader form, because I think this is something that our president of the court also needs to be involved in. We don't take this lightly at all. And I'm sure that the last word has not been said yet. At least we have heard Solicitor General Hawke make the apology. His undertaking that the apology will be published. That's a first step. But if it is, whether it's enough or not, that is to be seen. So let that be the message.
Thank you, President.
Let that be the, yes?
I'm seeing Madam Justice Rochnatley, and I'm seeing Mr. Mendes would have had his hand up. I don't know if we have the time based on what Justice Anderson
President, I'm afraid, President, that I may very well have to beg your excuse because I have another meeting which I have to attend.
Okay, but very shortly, Justice Rochnatley.
Yes, I just wanted to say thank you, President, but I will not be long at all. I wanted to say that apart from the apology and all those other things that I've heard today, I am very concerned about the impact on the integrity of the court.
Yes.
And I would like counsel here perhaps to come up with something that will remedy that impact. It is a very, very serious matter. Thank you. That's all I wish to say. And I see Mr. Mendes has had his hand up for a while.
Mr. Mendes.
Thank you very much, Your Honor. Just to say in relation to a concern that Justice Witt had expressed about whether the impression might have been given that the court was communicating only with the Attorney General. Just to point out that I'm seeing on Facebook that the Attorney General had posted something that said that this is apparently subsequent to the Facebook post, that the judgment had been dispatched by email to all lawyers representing the parties.
Yeah. Okay, but apparently that impression was created. So it only comes to show how dangerous these things are. If we cannot have any trust in counsel or in the Attorney General's office, I'm not even speaking about the Attorney General himself, but you have to organize your stuff in a way that this cannot happen. That must be absolutely clear. So let me keep it at that. We will give further consideration to this situation by the court in total, and I suppose you will hear what the court will decide on this point. Justice Rochnatley, your hand is still up, but that's not the idea.
It's only because I have not lowered it. Sorry.
Okay. Okay, so we'll keep it at that now, for now. But I think you will leave with the impression that the court is very displeased, and that is the correct interpretation of what we have said. So thank you very much for attending, and you, acting registrar, you could close the proceeding.
Thank you, judges, and thank you, counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.